Hi everyone, we continue with this workshop and we have the Professor Sandy Steele. He's a professor of law and philosophy of the University of Oxford, and he will give us this speech about liability for permissible harm. Sandy, it's your time.
Thank you. Oh, thanks very much for the invitation to be here. It's lovely to be in Girona and to speak today. So my topic is liability for permissible harm, and my talk's going to be centered around three main questions. So, does everyone have my handout, by the way? It was circulated quite late, but I hope you have it. So the three questions are as follows. The first one is, are there examples of non-contractual duties to compensate for harm in the absence of wrongful conduct in the common law, mainly English law? I think what I say though will be of general interest. It's not really so much focused on particular common law jurisdictions. I think there will be civilian examples of the phenomena that I'm discussing. The second one is, does the law adopt a consistent approach to these cases? So if we can identify situations in which people are held liable to compensate for harm that they've inflicted entirely permissibly, is the law adopting a consistent approach to those situations? Thirdly, are there any good normative justifications for compensation in cases in which a person has inflicted harm non-wrongfully? So it spoils the fun a little bit, but here are my answers in advance. Here are my answers to the questions. So the first one is, yes, there are examples. The talk wouldn't be very long or interesting if there weren't any examples. So there are examples of this in the law. Secondly, no, the law doesn't adopt a consistent approach to these cases. And thirdly, yes, there are good normative justifications for compensation in the absence of wrongful conduct. But my thinking, I suppose, on the last question is the least developed, and so I'm particularly interested in your thoughts about what I have to say on that. So why is this interesting, or why is this of interest? Well, there's a recent wave of tort theory which focuses on the idea of wrongdoing, and that liability, particularly liability to compensate, is justified by wrongdoing in some sense, and it's part of the standard way of thinking about tort laws, that tort law is a law of wrongs. But there's a set of cases which, as I'm going to explain, I think pose a lot of difficulties for this view, or at least they call for explanation if you accept the wrongs-based view of tort law. Either descriptively you think that tort law is a law of wrongs, or that morally you think that liability ought only to be imposed if there's wrongful conduct. These cases pose a difficulty, and they at least put pressure on the idea that wrongdoing has really much relevance to why people have duties to compensate. At least they show that it's not a necessary condition of a duty to compensate. Secondly, I think there's a moral puzzle about these cases of duties to compensate in the absence of wrongdoing. So in some of the cases I'm going to discuss, it seems that the person even is required to inflict the harm. So it's not simply that it's permissible, it's optional for them to inflict the harm. So they're actually required morally to inflict the harm. So it might seem puzzling that someone who is morally required to inflict a harm then has a duty to compensate for it. That seems like morality is being very demanding in some unfortunate way there. It's requiring you to inflict some harm, but then saying, now you've got to compensate for it. Can that really be justified? So that's the part of the moral puzzle. The third reason why I'm looking at this is that I think that while there's been a lot of attention about particular examples of cases of liability in the absence of wrongful conduct, thinking about them as a whole and collectively, and whether the law is adopting some kind of consistent approach to this phenomenon, I think has received less attention. And hopefully what I'm going to be able to bring out in the talk is that when we look at these cases in the round and set them against each other, we can see that the law hasn't really adopted a very consistent approach to this general phenomenon. So a couple of clarifications just before I get into it. Firstly, I'm going to be talking about moral permissibility, so liability for morally permissible harm. So that might raise some eyebrows, because you might think I'm just going to be telling you my subjective moral opinions about whether harm is permissible or not. But I'm going to focus on cases in which I think most people would agree that the harm was permissible. So most moral theories in these situations would converge on the conclusion that inflicting the harm was permissible, whether you're a consequentialist or a non-consequentialist. So long as you're not an absolutist non-consequentialist, you're going to think that in some cases a person's rights can be permissibly infringed and that it could be justifiable to do so. And the reason I'm focusing on moral permissibility is, and by the way, some of the examples, it could be true that it's legally permissible too, but in some of the examples it's just not clear, so perhaps some cases that it's legally impermissible. The reason I'm focusing on moral impermissibility or permissibility is that I think that's the source of the puzzle. Is like, how could it be true that morality is saying it's permissible to inflict this harm or it's required to inflict this harm, but yet then requiring you to compensate for it? By permissible harm, I also mean harm that's all things considered permissible. So all things considered contrast with pro tanto. Some of the cases, inflicting the harm is pro tanto impermissible, but it would either in the normal case be impermissible to inflict this harm, or that there is a reason against inflicting the harm that amounts to a duty not to inflict it, but the duty is overridden by more important considerations which make the harm all things considered permissible. So the focus of the paper is on cases in which the harm is all things considered permissible morally to inflict. Another distinction, sorry, at the beginning, between fact relative permissibility and evidence relative permissibility. So some of my examples are going to be involving cases in which the facts as they are in the world justify the conclusion that inflicting the harm was all things considered morally permissible. In other cases, it's just that on the evidence available to a reasonable agent, such a person could infer that it would be permissible to inflict the harm, even if all the facts were known, it would be clear that inflicting the harm was not permissible. So, roughly speaking, I'm going to just call this objective permissibility and subjective permissibility. But subjective permissibility are really cases in which a reasonable person could believe that there is a justification for inflicting the harm, but relative to the facts, it turns out that there was no such objection, that there was no such justification. Okay, so examples of this phenomenon that I'm going to talk about. So these are examples where I'm arguing that inflicting the harm was permissible in the sense I've described morally, but yet there's a duty to compensate. Okay, so the one that everyone knows is Vincent in Lake Erie. So Vincent in Lake Erie is the case of a captain of a ship who, in an unforeseeable storm, damages the plaintiff's dock in order to save the more valuable cargo on the ship. The Supreme Court of Minnesota says it doesn't matter that you did the right thing here, and the court actually says this was the right thing to do in the circumstances, but you still have a duty to compensate for it. Now, in a way you might say, well, is it really true that damaging another person's property to save more valuable property, is that necessarily morally permissible? You might think, well, it's just excused in the circumstances, but it's still morally wrong in some sense. But imagine a variation on Vincent Lake Erie where instead of saving property, he's saving his life. I think it's a pretty implausible view of morality that says you're required to allow yourself to die in order to save another person's commercial property. It just doesn't seem consistent with views about the importance of human beings, that it could be true that you're required to die rather than to allow another person's property to be damaged. And it seems clear that even if you're saving your own life, you still have the duty to compensate. It's also particularly clear in other legal systems like German law under 904 BGB, where you would be required to compensate even in that instance. Some contrast places which are going to be relevant to my discussion of consistency. So contrast the liability in Vincent and Lake Erie, where A damages B's rights in order to protect A's rights, with cases in which A damages B's rights in order to protect C's rights. So some unconnected third party, so where A and C don't have any connection to each other, where they're strangers. That would be described normally as a case of public necessity. So Vincent and Erie is a case of private necessity, where I'm damaging another person's rights to save myself, to save persons who are closely connected to me in some way. Public necessity is a case where I damage another person's rights in order to protect the rights of unrelated strangers, or our right. It could just be a single person of an unrelated stranger. And the general view tends to be that in public necessity cases, I don't have a duty to compensate. So the law draws a distinction between cases where I'm acting to protect myself versus where I'm acting to protect unrelated third parties. Contrast also Vincent and Erie with a rule which is called the common enemy rule in the common law. So the classic example of this rule is where we're two adjoining landowners, and I know that a storm is coming towards my land. So in preparation for this, I build a gigantic wall on my land, knowing that sadly, I'm afraid it's going to damage your land seriously. And in these circumstances, the law says I'm permitted to build this wall, knowing that it will cause damage to your land, and I don't have a duty to compensate you. That's the common enemy rule. So in situations in which in some sense we face a common danger, and I take a protective measure, knowing that that protective measure will cause damage to someone else who shares that danger in some sense, I can do so, but I don't have a duty to compensate. So notice the structural parallel though between this example and Vincent and Erie. I am doing something knowing that it will damage another person for my own benefit, but I don't have a duty to compensate in this situation. Second example, compensation which is awarded instead of an injunction in cases involving invasion of property rights. So there's a bunch of reasons why courts refuse injunctions, why they refuse to give an order to stop the doing of some action. So some of these have nothing to do with the justifiability of the defendant's conduct. Some of them are to do with the claimant's conduct, because say the plaintiff has taken too long to bring the case to court, or they've got unclean hands is one justification. These have nothing to do with the justifiability of the defendant's conduct. But sometimes the courts refuse an injunction because they conclude that actually the activity ought to be allowed to continue. But sometimes even when the courts conclude that the activity ought to be allowed to continue, that's consistent with thinking that the activity is all things considered wrongful. So imagine that someone is standing on my toe for no good reason. That's a wrong. That's all things considered wrong. But imagine that the only way I can stop the wrong is by decapitating the person. It would be wrong to do so. But it's still clear that the person is committing an all things considered wrong against me. So sometimes it could be disproportionate, in other words, to stop an all things considered wrong. So sometimes though the courts are saying not simply it would be disproportionate to stop this all things considered wrong, they're actually saying the defendant's doing the right thing. So I think a good example of this is Denison Military Defence. So this is a case involving jets which are travelling across the claimant's land. So the RAF, the Royal Air Force, is running a jet training programme across the claimant's land, and this is very, very noisy. And it constitutes a private nuisance, so an invasion of the claimant's property rights. Judge says, I'm not going to stop this because it's in the public interest. He says, I hold that the nuisance is established, but the public interest clearly demands that RAF Wittering should continue to train pilots. So on the face of it, he seems to be saying there that this is the right thing for the defendant to be doing in the circumstances. Yeah, it's invading this person's rights, and it might be said to be pro tanto wrong on that basis, but all things considered, this is what they ought to be doing. So you might say, you know, we shouldn't have a Royal Air Force, and so this wasn't really the thing that they ought to be doing. But I think we can come up with parallel examples where we might be willing to agree that there are situations in which it's permissible to invade someone's property rights for some broader public good, but nonetheless think that they ought to be compensated. So that's another set of examples. Okay, so the next set of examples are different because they all relate to evidence relative permissibility. So these are cases in which, relative to the evidence, it's permissible to inflict the harm, but actually relative to the facts, it would be impermissible to inflict the harm. So the first category are cases where a court orders you to pay compensation for an interim injunction, which has turned out to be incorrectly awarded. So these are cases in which I suspect that someone is violating my rights. I go to court in order to get them to stop. But I go to court prior to trial, so before we've been able to establish the facts with any reliability, I get the court to order an injunction to get them to stop doing what I claim is violating my rights. In these circumstances, the courts will normally require me to promise to pay compensation in the event that the injunction has been incorrectly awarded relative to the facts. So if it turns out at trial that the person is not violating my rights, and so the injunction relative to the facts was incorrectly awarded, I have to compensate them for the loss that the cessation of their activity has caused them. Even although I'm acting reasonably relative to the evidence in bringing the injunction, so I might entirely reasonably believe that my rights are being violated, but it's a condition of me being entitled to the other person stopping the activity that I have to pay compensation in the event that it's mistaken. So you might say there, well, isn't the justification of the liability the promise? So isn't it simply that I promise to pay compensation, and so the duty to compensate is just an entailment of that promise? But I think the interesting point is that the courts clearly consider it justifiable to insist upon the promise being made. So they think there are good independent moral reasons for why we think the defendant ought to promise to compensate in these cases, independently of whether they have made the promise. So the courts are saying, in these circumstances, if you choose to bring this, if you choose to get us to award this remedy against the defendant, you have to compensate if things go wrong, even although you've acted entirely reasonably. And that's why we're getting you to make this promise, because there's an independent moral reason for your compensating the defendant in these cases, the claimant. All right. Another example, not much discussed in compensation literature, but I think quite an interesting one, is compensation for mistaken convictions. So judge reasonably believes that you're guilty, convicts you, turns out you're not, the new evidence comes out, and there's a statutory right in English law under certain circumstances to be compensated there. But the state has acted relative to the evidence permissibly in imprisoning you. So relative to the facts, they've wronged you, but relative to the evidence, they behave permissibly. There's a bunch of cases in which, this is my final set of examples, in which you're awarded compensation even though the person had a reasonable belief that there was some justification for what they did, or that they had permission to invade your rights. So in English law, if I reasonably believe that I have permission to touch your property or to go on your land, that doesn't matter in terms of compensation. I still have a duty to compensate you for the use that I've made of your land. So a reasonable belief that I have permission isn't relevant to the liability to compensate. But contrast that with self-defense. So if I reasonably believe that someone is attacking me, the law has edged towards the position that that is a defense to the duty to compensate. So if I reasonably think that you're attacking me and I acted to harm you in what I believe to be self-defense, I don't have a duty to compensate you according to these cases. And there's a bunch of other examples, like police officers have a reasonable belief that you're committing a crime, or a reasonable belief in a lack of capacity. If someone is detained because the authorities think, or a person thinks that they lack capacity and are a danger to other people. There's no liability if there's a reasonable belief that the person lacks capacity or that they're likely to attack someone. Okay, so is the law adopting a consistent approach to these cases? We'll consider first of all the contrast between private and public necessity. So the distinction between cases where I damage another person's rights for my own interest versus damaging another person's rights to protect unrelated third parties. Well, two arguments are commonly given to justify this distinction. One of them is an incentives argument, which is that, in cases where I'm acting for my own interest, I'm not going to be dissuaded by the threat of liability from doing so, because I'm not going to in Vincent and Erie, even if I know I'm going to have to compensate the dock owner, I'm still not going to allow myself to die in those circumstances, even if I know it's going to be pretty tough to compensate the dock owner. But it might dissuade me from helping other people, not me personally, of course, but it might just dissuade some people from intervening in these cases if they know that they'll have to compensate for any damage they do. So even though we want the person to intervene in these cases because it's justifiable ex hypothesi to do so, and it could avert some moral catastrophe, someone might think, well, I can't afford the £2,000 cost of repairing the dock, so I'm not going to intervene. So I actually think the argument, at least in assuming the absence of widespread insurance against this type of event, is actually pretty plausible. That there is a real risk that people won't intervene in the public necessity cases because of this incentives reason. For reasons I probably don't have time to explain, I think incentives arguments are relevant to decisions about which liabilities ought to be enforced in law. So the fact that imposing some duty of compensation would have negative consequences is just relevant to whether we ought to do so, regardless of whether there's a moral duty to compensate in circumstances. So even supposing there's a moral duty to compensate in the public necessity cases, it could still be legitimate for the law not to enforce that duty because it's going to have negative consequences in terms of people's interventions in these types of scenarios. There's another argument which I'm going to explain later, the fairness argument against liability and public necessity. And for now, I just want to draw attention to the different feature of this argument. The different feature of this argument is that at a fundamental moral level, this argument claims there is no duty to compensate. So the incentives argument could concede that there's a moral duty to compensate in public necessity cases, but it shouldn't be legally enforced because of all of these negative consequences that might ensue. And I find that pretty persuasive, the incentives bit of it. But the fairness argument says, no, actually in these cases of public necessity, there's no moral duty to compensate. There might be a reason to compensate. It might be particularly intelligible that you would want to compensate in these cases because you inflicted harm. But it's not a duty that another person can demand of you that you compensate in these cases. And that's an argument that I'm going to have, or at least a claim that I'm going to express some sympathy for later. But I think even if you reject what I say about that, we could still defend public-private necessity, the distinction, on the basis of the incentives argument. Okay, take the different contrast between public necessity cases and the compensation instead of injunction type scenario. So the common thread linking these two cases is that in both situations, A damages B's right, but the damage is justifiable for public good reasons, or for the good of other people. But in public necessity cases, there's no liability, but in the compensation in lieu of an injunction cases, there is liability. So is this an inconsistency, or can it be explained away in some way? Well, the Dennis case about the Air Force is of course a slightly unusual case in that it was the government that was inflicting the harm, or it was the state that was inflicting the harm. So you might say, in a sense, it's kind of like a private necessity case. So the state is acting for its own benefit in inflicting this harm. So it's fair that the state and people who constitute that state pick up the costs at the end of the day, or the citizens of the state at least pick up the costs at the end of the day. So I think you could say that in Denison military defence type situation, where the state is the person inflicting the harm, that it's actually more like a case of private necessity, because the person inflicting the harm is inflicting it for their own benefit. It just so happens that the public benefit is also that person's own benefit, because that person is the state in that type of case. But the difficulty with that is that this compensation in lieu of an injunction goes beyond cases involving the state. And so there are some situations in which the courts suggest that they refuse an injunction because, so they won't say close down a factory, close down business because it produces employment in a local area. And so they're appealing, and they describe this as an issue of public interest, that we're not going to shut down this factory because it's providing a lot of jobs in this area. It might be infringing this person's rights, but it's producing a lot of employment in the local area, and that means we can't shut it down, but we're going to require you to compensate for the harm you're doing. So there it seems like, again, you're acting in the public interest, partly at least, but you are under a duty to compensate. So how do you reconcile that with the absence of a duty to compensate in the public necessity cases? Well, I think one possible reconciliation is that a lot of these cases are sort of mixed motive cases, if you like, where the defendant is acting partly in the public interest, but their predominant motivation is the private interest, is doing business. So it might be that there's this ancillary benefit for the community as a whole of employment, but their primary aim in acting is a profit-making one. So in a sense, I think that might still allow us to treat these as predominantly like private necessity cases, and so avoid the conflict in that way. Okay, here's an inconsistency which I find more problematic, or which I think is a genuine inconsistency: the difference between private necessity and common enemy rule. So again, the fundamental structural parallel between these two situations is that A is causing damage to B's right in order to protect A's own good. But in one case you're under a duty to compensate, and the other you're not. So one possible distinction between the two is a distinction between using a person as a means and causing damage as a side effect of your action. So typically when people talk about the private necessity cases, they tend to imagine cases in which you're using another person's property in order to benefit yourself, in order to protect yourself from some harm. And the use of the person's property is crucial to your success. Whereas in the common enemy type situation, when I build the wall, which affects Henry's land, it's a side effect of my action. It's not crucial to my success in protecting my land that his land be damaged. So you might think, well, isn't that an important moral distinction that maybe the law is tracking here? So I think there is a moral distinction between using a person as a means and knowingly causing damage as a side effect of your action. But I suppose the question is it a powerful enough moral distinction to justify the absence of a duty to compensate in one case, but the presence of a duty to compensate in another? And to my mind, they're pretty morally close. They're not. There's a moral difference there, but I don't think the moral difference is so fundamental that it could justify this stark distinction between a duty to compensate and the absence of a duty to compensate. It's also worth pointing out that in Vincent and Lake Erie itself, it looks like the harm was actually inflicted as a side effect of the action. It wasn't it wasn't harm inflicted by using the defendant as a means. Because in Vincent and Lake Erie, what actually happened was they tied the boat to the dock, and they knew that in doing so, the storm was going to bash the boat against the dock. But the damaging of the dock wasn't necessary in order for them to be protected. So it wasn't that harming them was a necessary causal means of their self-protection. The damage was a kind of incidental feature of the situation. They knew that it was going to damage, or they could reasonably be expected to have known that it was going to damage the dock, but that wasn't necessary for the success of their self-protection. So in a sense, Vincent and Lake Erie is itself a side effect case. So if that's the kind of paradigm of private necessity case, well, that would suggest even more that there ought to be some kind of there's an inconsistency with the common enemy type situation. A different distinction points to this being about common enemy in some sense, that in these cases of common enemy where we are joining landowners, there's a sense in which the risk affects us both, and that we share the risk in some way, and that makes a moral difference. So in a particular case, if the storm is coming towards my land and I build the wall and it damages Henry's land, there's a sense in which the risk isn't shared in the particular case. So the risk was going to affect me, and I have shifted it to someone else. So if we think about the particular case, it's just not true that the risk is a common one or a shared one. The risk was going to particularly affect me, and I've just shifted it to someone else. In the same way, if a boulder was rolling towards me, as they do in philosophical thought experiments, if a boulder was rolling towards me and I just decide to shift it to Henry, that's a bit naughty, I think. You shouldn't do that. And even although it could have been the case that the boulder was rolling towards him, but the boulder was actually rolling towards me, so the risk is particular to me, and then I'm just shifting that risk to someone else. So I'm just not true in these common enemy type situations that there really is a sense in which the risk is shared in a particular case. There's maybe some more complex possibilities that I could explore in questions, but I'll move on. So I think there is potentially an inconsistency there. A different set of inconsistencies are between private necessity and cases in which you make a reasonable mistake in the enforcement of your rights. So the common thread here is that A damages an innocent person, B in order to protect A's own good. So if I reasonably believe that someone is attacking me and I injure them, I'm damaging an innocent person to protect myself, to protect my own good. And in the private necessity type situation, we think that's enough to justify, or the law seems to think that's enough to justify me being under a duty to compensate. Damaging an innocent person's rights in order to protect one's own interest equals duty to compensate on the face of it, according to the private necessity cases. But then when you get across to the reasonable stakes of self-defense, the law's saying, no, there's no duty to compensate there, even though you've injured an innocent person for your own benefit. I think that's difficult to sustain. That if you accept liability in the private necessity situation, you are also to accept that there's a duty to compensate for reasonable mistakes made in self-defense, which are relative to the facts wrongful. And it's also worth noting how close the damages on the damages for an interim injunction case come to cases of self-defense. So when you go to court and you get an injunction, it's possible to think of that as a form of self-defense. So you're getting another person, the court, to act in such a way to protect your rights ex ante. So when you get an injunction, it's a kind of self-defense of your rights, but through the agency of the court. And in those cases, you are making a mistake. So you're going to court, you're getting the court to act in self-defense for you, and the court's saying, well, you have to compensate if we make a mistake. Well, that just is self-defense going through the institution of the court. But in cases in which there's no institutional self-defense, just a pure self-defense case, the law is saying there's no duty to compensate. So I think again there's an inconsistency there. Finally, in relation to consistency, if we think about all of these cases in which, so the law says a reasonable belief in consent doesn't relieve you of a duty to compensate, but a reasonable belief in self-defense does relieve you of a duty to compensate. I'm not able to identify a good reason for that distinction as to why consent gets treated differently from self-defense. So in both cases you are objectively infringing another innocent person's rights, and you reasonably think that you've got some good permission or good reason for doing so. But in one case you're under duty to compensate, but not the other. The only thing I can think of is that in the self-defense case we might be worried, we might have this kind of incentives argument on our minds again, that if we impose liability in the self-defense case, people won't act in legitimate self-defense. So they might be worried, well, am I making a mistake here? And in which case I'm going to be under a duty to compensate. in which case I might not actually protect myself, even when I legitimately ought to be able to protect myself. I just find that psychologically implausible in most cases, that people are going to be thinking about tort liability when they're being brutally attacked. So I just don't see a good reason for that distinction. Okay, let me move on finally to justifications. How am I doing for time?
You're good.
Good, okay. So, is there any good justification for duties to compensate in these sorts of situations? So one that you often find in the legal literature is this idea of a conditional permission, which an author called Francis Boland is often cited for in this article from the 1920s in the Harvard Law Review. And the idea here is that sometimes the permissibility of an action comes with a condition. Sometimes it's permissible to inflict some harm only if you do some further action later. So Victor Tadros has this nice phrase where he says that permissibility can sometimes come with strings attached. So the idea in the Vincent case would be that you are permitted to inflict the harm, but only on condition that you compensate. So the permissibility of the infliction of the harm comes with this condition that you have to compensate. So I've got two problems with this general line of explanation or justification of this liability. So the first one is a problem of analytical fit. So this is a claim about the normative structure of these cases. And I just don't think it accurately captures the normative structure of some of the cases at least. So if we think about the Vincent case where I'm acting to protect my life, so is it true that the permissibility of damaging the dog depends upon me later compensating for the harm I've done? Well, suppose that I know, and suppose that a bystander knows that I will not be able to compensate. I'm an insolvent layabout who never does anything, and it's just going to be impossible for me to compensate. So if I know that the condition under which my act is permissible will fail, that won't materialise, it seems to follow that it would be all things considered impermissible for me to damage the dog. So I would be morally required to allow myself to die if I know that I won't be able to compensate in the future for the harm I've done. That just doesn't seem plausible to me, that I'm morally required, all things considered, to allow myself to die to save property if I know that I won't be able to compensate in the future for it. That doesn't seem to me to accurately capture the normative structure of these cases. It seems better to me to say, if you damage someone's stuff permissibly, sometimes you have a duty to compensate. It's not that the permissibility of your initial action was conditional upon some later action. It's just that sometimes permissibly harming generates duties to compensate. We don't need to make the permissibility of your initial action conditional upon some later action. And that doesn't seem to capture what our moral intuitions, or at least my moral intuitions, say about these cases. A second problem with this is just that it doesn't seem to me to give us any normative explanation of the liability in these cases. So why isn't my permission to harm someone in self-defense conditional? Very few people would be content with that conclusion. So if someone's attacking me in I'm permitted to defend myself. But why isn't that permission conditional? This, in and of itself, reference to conditional permissions doesn't really get us very far, it seems to me. It might be an accurate description of the normative structure of these cases, but it doesn't give us any deeper normative explanation of why liability is why the permissibility of an action is conditional in some cases, but not others. So it could be that this could be more fully worked out into a general theory of these sorts of cases, but it seems to me that, at least as it's offered often in the literature, that there isn't this deeper explanation of why the permissibility of some actions is conditional and why it's not in other cases. So maybe the most popular explanation or justification of the liability in these cases is an appeal to a certain conception of rights. So Judith Thompson and Joel Feinberg both try to explain the duties to compensate in these cases on the basis that it's sometimes permissible to infringe a right. So rights, in one way of understanding the notion, are not necessarily all things considered judgments about what you ought to do, but rather inputs into moral deliberation, which typically silence or cancel or exclude other considerations, but sometimes can be overridden in certain situations. And the Thompson-Feinberg view is that, well, in these cases where you infringe permissibly a non-forfeited, non-waived right of another person, the reason you have a duty to compensate just is you infringe their rights. So it might be that you acted, all things considered, permissibly by reference to these other more important considerations, but it's still true that you infringe their rights. And so that's the explanation of the duty to compensate in these cases. And that works quite nicely for Vincent and Lake Erie. So I might be acting permissibly, but I've still infringed your rights. And it seems to also, it would be an explanation for the Denison military defence type situation as well, that RAF is infringing your rights, might be justifiable for public good reasons, but they still have a duty to compensate. It would help to justify, I think, the compensation for interim injunction cases, and that you generally have a right not to be forced to depart, to give up your assets for the benefit of another person. That right's been infringed for public good reasons. So it's got some explanatory fit with the law. But I think the difficulty for this view are cases which Feinberg and Thompson don't consider, involving third-party interveners. So if you take a variation on Vincent and Lake Erie, where imagine that a stranger comes on the scene of this version of Vincent and Lake Erie, and the only way that they can save the lives of the people on board, suppose they're all unconscious for some reason, is by attaching the boat to the plaintiff's dock in this example. So it's clearly justifiable to do so, even knowing that it's going to cause some damage to the dock in the circumstances to save the lives of the people on board. Now, on their view, it would follow that the person who attaches the dock is under a duty to compensate because they've infringed the rights of... So the altruistic intervener has a duty to compensate in these situations. Now, initially, when I was writing this in the quiet solitude of my room, I thought that this is just that everyone would share my intuition that that's crazy, that the thought that the altruistic intervener would have a duty to compensate in these sorts of situations, and that there's quite a powerful intuitive case against the Feinberg-Thompson view. But actually it turns out that other people sadly disagree, and that other people have the intuition, yeah, that you have a duty to compensate in these situations, and it's kind of just tough. So I've been trying to think about how to explain further the intuition that there is no duty to compensate in the Storm 2 type example. This is on page 3 of the handout. So one explanation, one contrast between the two cases where you're acting for your own benefit and acting for the benefit of the third party is that in the cases where you're acting for the benefit of the third party, you might say there's a moral requirement if it's easy for you to intervene, to do so. So you're morally required to intervene in those cases. Whereas in the Vincent and Lake Erie original scenario, it's just a matter of self-interest. You know, that you might say, well, it's an unfortunate situation, but you're not morally required to save yourself. So, you know, we could have a debate about whether that's true and whether you are actually morally required to save yourself in those circumstances. But it seems to me that, first of all, it's difficult to justify a distinction between moral requirement and just having no reasonable alternative. So why do we think that moral requirement should be so special when it comes to duties to compensate? So in the Vincent and Lake Erie situation, there's a sense which I don't ever, you know, am I really being asked to die instead of damaging the person's property? So I've got no reasonable alternative. So there's a sense in which I have no other choice except to damage the dog. So in both cases, morality is saying, in the third party intervener case, you've got no choice, you've got to do this. In Vincent and Lake Erie, self-interest is saying, and it might be other interest too, that you have to intervene, so you've got no reasonable opportunity. So I don't think it can simply be a distinction between moral requirement and other forms of requirement. Also, if you thought it was about moral requirement, you would get an odd distinction in cases of supererogation. So suppose that inflicting the harm would be above and beyond the call of duty for me. So in the third party's interveners, the Storm 2 case, imagine that when C, the intervener, damages the property, suppose that they're going to lose 2 of their legs in damaging the property. So most of us probably think that that's above and beyond the call of duty, and you're not required to sacrifice 2 of your legs even to save the life of another person. But it would be true that you're not morally required to inflict the harm in these cases, so it would be supererogatory to inflict the harm in these cases. So in a sense it would be a choice again for you to inflict the harm. But it seems like a very odd result that in that case then again you would be under a duty to compensate. So where you acted as a moral hero in the circumstances in inflicting the harm and you sacrifice both of your legs to save the life of another person, but you still have the duty to compensate there. But you don't have it in a case where it was really easy to intervene and damage the person's property to save another person. So the explanation that I'm tempted as to why these 2 cases are different is that in the case of the altruistic intervener, where the costs of the intervention are low, the intervener, the person who's damaging the dog to save the third party, it's as if they were enforcing a duty of easy rescue, which the property owner has to the third party. So if the property owner was there, they would have a duty to permit the interference, so a moral duty of easy rescue, which would require them to allow the interference in these circumstances. So if you see someone about to die and they need the use of your dog, if you accept the existence of moral duties of easy rescue, probably think that they've got a duty to allow the use of the dog in the circumstances. So when a third party comes along, it's just like they're enforcing that moral duty of easy rescue that would exist if the property owner was actually there on the scene. So where you are inflicting damage which a person would be under a moral duty to bear in those circumstances, you might think, well, that's why there's no duty to compensate, because this is a cost which you would be morally required to bear anyway in the circumstances. Now, you could say the same about Vincent and Lake Erie, though, that in Vincent and Lake Erie, where you're acting for your own benefit, the property owner also has a duty to allow you to use the dog. But it seems to me that the quid pro quo for the dog owner having the duty of easy rescue is that they get compensated for the damage that's done to their dog. So as a sort of matter of fairness, in return for this duty to allow the other person to use your property or even to come to their assistance, the damage you suffer in fulfillment of that duty is fairly borne by the beneficiary, or the person for whom the duty arises. So a duty to compensate would arise in that case on the part of the beneficiary, because they're the person whose interests grounded the duty to rescue in the first place. So the thought is that what distinguishes the 2 cases is in the second case, in both cases, the property owner has a duty of easy rescue, but only in the Vincent case, in the original case where you're acting for your own interest, the person who benefits from, who's the beneficiary of the intervention, has a duty to compensate, because they're the ones whose interests justified there being a duty of easy rescue in the first place, or justified the permissibility of the intervention. Sorry, that wasn't terribly clear. Maybe I can try and clarify it in questions. I'm probably not going to get to Storm 3 because it's going to introduce another complexity. So the principle that I'm kind of tempted by, and as I say, my views on this are pretty tentative, is the final principle that I put on the sheet. This sort of idea that it depends upon whether you have a duty to compensate in these cases, depends upon whether you're the beneficiary of a permissible rights infringement. So in the public necessity cases, and in the cases in which, in like Vincent and like Erie, you're benefiting from the interference. And it's not simply that you actually happen coincidentally to benefit, it's that your interests are the interests which grounded the permissibility of the interference. So there are two conditions under this principle. Firstly, that your interests are the ones which grounded the permissibility of interfering with someone's rights. And secondly, that you actually got the benefit which that permission is designed to secure you. And in those circumstances, it seems to me that there's a kind of fairness intuition that generally morality is not keen on people violating others' rights, but exceptionally it permits such interferences because of overwhelming considerations of other people's good. But where that happens as a kind of quid pro quo for this exceptional permission to interfere with another person's rights, if your interests were part of what grounded the permissibility of interfering with another person's rights, it's fair that you bear part of the costs of this exceptional intrusion that morality is making into the normally protected sphere of individuals. So if you accepted right to benefit, you would have this explanation which distinguished between the private and public necessity cases, but would provide a justification for liability in the other types of situation that I've described. So I will stop there.